Welcome, everyone, to Bracewell's webinar on drafting effective separation agreements. I'm Amy Halevy, and I'm here with my partner, Bob Nichols. In the right corner of your screen, there should be a box to submit questions. If we have time, we'll address those at the end of our presentation. If there are questions we don't get to, we'll follow up with you sometime later. I also want to let you know that this program has been credited for 1 hour of Texas CLE. In reviewing the topic of separation agreements, I think the first question employers should ask is whether or not they want to offer the employee a separation agreement. Clearly, it will not be the right call in every situation. So let's go through some of the reasons why employers offer an employee a separation agreement. First, keep in mind that in some situations, an employee is entitled to severance only if he signs a release. So in that situation, the employee has to be presented with an agreement. In other situations, particularly if the employer is concerned about potential claims, the employer may want the employee to sign an agreement to ensure that there'll be no future issues. Closure. There are also situations where the employer wants to give the departing employee something he's not otherwise entitled to in order to just ease his transition from the company. And in that situation, it may make sense to provide the employee who's getting additional money with a release. Another reason to have a separation agreement is to help reinforce an employee's post-employment obligations, like the duty to maintain confidential information, duty not to disparage, or duty to cooperate with the company. But be cautious about tacking on post-employment covenants to a separation agreement that may not be enforceable, such as in Texas, a covenant not to compete is unlikely to be enforceable if it shows up for the first time at the end of employment and in a separation agreement. Now, what are some of the disadvantages of a separation agreement? First, you have to give the employee consideration for signing the release, and that usually means money. Additionally, a separation agreement takes time to prepare, and the employee, as we'll talk about, needs to have time to consider whether or not to sign it. If the employee is over 40, you have to give the employee at least 21 days, and in some situations, 45 days to review it. And even if an employee is under 40, the employee should have a reasonable period of time to review the agreement. Additionally, and we have certainly seen this in the Me Too era, employers should be thoughtful about giving departing executives, particularly those who have engaged or allegedly engaged in misconduct, a lucrative severance package. We saw this issue recently with the uproar over Les Moonves with TBS and his $120 million severance package. Employers should consider whether, from a corporate governance perspective, it makes sense to offer the separation agreement. An employer could face shareholder derivative suits, and we've certainly seen some, if an executive who may have engaged in wrongful conduct is given a high-dollar severance package. Once the employer has decided to offer a separation payment in exchange for a release, there are things that need to be considered before preparing the agreement and presenting it to the employee. First, you need to look at offer letters, employment agreements if they exist, change of control agreements, severance plans, or policies, any company document that could mention severance. Now, in terms of starting to draft the agreement, many companies rely on templates. And that can be a good place to start, but be careful of those. Relevant time periods vary, depending, for example, on the age of the employee or whether or not it's a group termination. State law requirements vary. California, for example, has special language that needs to be included. The underlying documents related to the employee will often vary, and there may be obligations that need to be addressed in a separation agreement. Pretending, for example, if the employee has an employment agreement, management goals may vary. In some particular situations, you may really want to have that cooperation language in there, but you don't have it in others, or other post-employment concerns. Exclusions to zipper clauses will vary. Sometimes you'll want to carve out certain obligations, like, for example, if you have an existing covenant not to compete with an employee, and you want to make sure that this agreement, the separation agreement, doesn't extinguish that through a zipper clause. Legal considerations, as we'll be talking about this morning, change pretty rapidly, so that's something to keep in mind with regard to template. And finally, in some situations, a union may be involved, and the employer may need to consult with the union before offering a separation payment.
We want to talk today about some of the promises or covenants that find their way into separation agreements that can endanger the enforceability of the agreement or subject the employer to potential penalties under law. One of the thorniest, and perhaps the thorniest type of provision we've seen in recent years under legal developments that find their way into separation agreements is confidentiality promises. There are two types of confidentiality promises in separation agreements. One is simply a promise to keep the agreement itself and perhaps the circumstances surrounding the agreement, the amount of the payment, confidential. The second confidentiality promise that many of you include in separation agreements is a promise or a reaffirmation by the employee to keep trade secrets and other confidential business information confidential. Under recent legal developments, as we'll discuss today, particularly issues involving a variety of federal agencies, these provisions, if not properly drafted or not accompanied by an appropriate disclaimer, can create legal challenges and concerns for you. With regard to confidentiality of the separation agreement itself, that provision, I want you to think about, in the case of reductions in force, group terminations, do you really need or want a confidentiality promise? And we worry about confidentiality promises to some extent in that context because, for example, under the ADEA waiver requirements we'll talk about, it's reasonable to expect that during the consideration period, employees involved in a RIF might talk among themselves about the reduction in force, about the disclosures they receive, and to force them to remain mum might raise, in theory, a legal issue. Also, as Amy alluded to, there's increasingly unique state law issues associated with these separation agreements. And as some of you know, in response to the Me Too movement, California enacted sweeping new laws impacting sexual harassment issues and other employment issues effective January 1, 2019. And under those new laws, Amy and I think it's probably inconceivable that you could legitimately, for example, have an employee keep a release confidential where it occurs in the context of sexual harassment claims that have been made by that employee. So you need to be careful about under what circumstances you can require the employee to keep the agreement secret. With regard to business information confidentiality, as we're going to talk about today, several federal agencies have weighed in on what you can do and what you can't do, and what they expect in terms of a disclaimer concerning unwaived rights in that regard. Finally, Amy made reference to zipper clauses. You also need to be careful in drafting your agreement that your confidentiality of business information provision doesn't appear to void prior promises the employee made in, for example, an employment agreement or a confidentiality agreement. Business confidentiality requirements in separation agreements should augment existing requirements and not replace them. I want to talk about probably the most significant federal agency concern associated with confidentiality provisions in separation agreements, and that's the actions of the SEC. I noted that recently the chief of the Office of the Whistleblower for the SEC, Jane Norberg, said, based upon cases that we're going to talk about today, that there's no excuse for employers, quote unquote, no excuse for employers not to get separation agreements right in terms of what the SEC will not permit. And after we talk about some of these cases, I think you'll have a sense for why Ms. Norberg believes employers should have gotten the message since 2015. The SEC whistleblowers are protected by Section 806 of the Sarbanes-Oxley Act of 2002, as amended by the Dodd-Frank Act of 2010. Those whistleblower protections apply to publicly traded companies and also apply to their privately held subsidiaries and affiliates if those entities are included in the consolidated financial statements for the publicly traded entity. Also, those SEC protections and prohibitions cover officers, employees, contractors, subcontractors, and agents of publicly traded companies. These confidentiality requirements are significant. These whistleblower protections are significant with regard to confidentiality provisions for two reasons. Your confidentiality provision can run afoul of the anti-retaliation protections the SEC has established. And also, as we'll discuss, your separation agreement cannot provide and cannot even suggest that employees' rights to receive awards from the SEC for whistleblowing are waived by your separation agreement if you're a publicly traded entity or otherwise a covered entity under SEC rules. So let's talk about the key rule when it comes to trying to keep employees quiet post-employment and SEC concerns about those provisions. SEC Rule 21F17A that was adopted in August 2011 in the wake of Dodd-Frank and is codified at 17 CFR Section 240.21F provides that, quote, no person may take any action to impede an individual from communicating directly with Commission staff about a possible securities law violation, including enforcing or threatening to enforce a confidentiality agreement with respect to such communications, close quote. And as you'll learn today, if you don't already fully understand this, that reference to confidentiality agreement definitely applies to confidentiality promises included in separation agreements. As we'll explain, especially since 2015, the SEC has utilized this particular SEC rule, 21F17A, to regulate confidentiality restrictions, not only in separation agreements, but in employment agreements, in codes of ethics and conduct, and other personnel policies. I want to turn now to Amy to offer you some explanation of what's happened since 2015 with SEC enforcement.
The first SEC enforcement action since Rule 21F17A was adopted involved KBR. As part of KBR's compliance program and its internal investigation process, the company used a form confidentiality statement that witnesses signed at the start of the interview. The confidentiality statement said that the employee was prohibited from discussing the interview and the subject matter discussed during the interview without the prior authorization of the law department. It also noted that unauthorized disclosure may be grounds for discipline up to including termination. The SEC determined that the confidentiality statement violated and undermined the purpose of Rule 21F17A, which is to encourage individuals to report to the SEC. As part of the remedial measures, which also included a $130,000 penalty, KBR agreed to include the following language in the confidentiality statement. Nothing in this confidentiality statement prohibits me from reporting possible violations of federal law or regulation to any governmental agency or entity, including but not limited to the Department of Justice, the Securities and Exchange Commission, the Congress, and any agency, Inspector General, or making other disclosures that are protected under the whistleblower provisions of federal law or regulation. I do not need prior authorization of the law department to make any such reports or disclosures, and I'm not required to notify the company that I've made such reports or disclosures. Shortly after the KBR case, BlueLinx in 2016 settled a similar action by the SEC. The focus of this action was the severance agreement. BlueLinx's agreement stated that the employee could disclose or use confidential information that was required to be disclosed by law or other legal process. However, the employee was required to provide the legal department with prompt written notice. The SEC objected to this language in the severance agreement, as well as language which said that nothing in the agreement prevents the employee from filing a charge with the EEOC, NLRB, OSHA, the SEC, or other administrative agency. However, the employee waives the right to any monetary recovery in connection with that complaint. The SEC determined that that language impeded an employee's participation in the SEC's whistleblower program. The Commission argued that BlueLinx was essentially forcing employees to choose between identifying themselves to the company as whistleblowers or losing their severance pay. Further, the SEC argued by requiring departing employees to forego monetary recovery, BlueLinx removed the important financial incentive that is intended to encourage persons to communicate directly with the Commission. As part of the settlement with the SEC, BlueLinx agreed to include the following language in its severance agreement. While the required language that you see on your screen is similar to the language in the KBR case, it goes farther than KBR. This language, which includes the EEOC, the NLRB, and OSHA, is really better to use because it is in fact more inclusive.
I want to talk about an interesting case from 2016 brought by the SEC against Anheuser-Busch and settled in 2016 that I think involves some interesting facts. An employee with Anheuser-Busch reported that he believed the company was violating the Foreign Corrupt Practices Act in India, and in fact, that ultimately led to $6 million in fines against Anheuser-Busch under the FCPA. Interestingly, the employee was actively cooperating with the SEC, and then the employee departed Anheuser-Busch and signed a separation agreement with Anheuser-Busch that included provisions that caused the employee to immediately stop talking to the SEC. What three provisions in that agreement led that employee to stop and caused SEC objections? They were as follows. First of all, there was a conventional confidentiality of business information provision included, a very broad provision. Secondly, there was just a confidentiality of the agreement provision like the one you see on the screen, and that is not very different than probably many of you have in your agreement. The third provision that the SEC had trouble with in the separation agreement said, employee, if you violate either of these confidentiality promises, you will pay Anheuser-Busch $250,000. And you can see why the employee immediately stopped talking to the SEC. The SEC found that these provisions were unlawful. Now, a very important point that Amy and I have discussed. The solution that was reached in the settlement was not to eliminate the confidentiality promises. Rather, it was to include an appropriate disclaimer, like Amy and I have talked about with you, to make it clear that the employee was free to communicate with the SEC and other agencies despite the provisions in the agreement. To show you that these continue to be issues beyond 2016 and 2017, BlackRock had a major SEC action against it over its separation agreements and confidentiality promises, and similarly agreed to new disclaimer language and paid the SEC $340,000. As I mentioned, Ms. Northberg, the head of the SEC's whistleblower office, she indicated in late 2017 that she thought that employers were doing a much better job in crafting agreements that were narrowly and carefully tailored and had appropriate disclaimers so as to comply with SEC expectations. And again, at that time, as I noted, said she saw no excuse for employers to get it wrong any longer. And it would appear under the current administration, the SEC's concerns with these confidentiality provisions have not gone away. These continue to be issues currently. I want to turn back to Amy now to talk to you about the concerns with confidentiality provisions raised by a different federal agency.
Like the SEC, the EEOC, the Equal Employment Opportunity Commission, has also gone after companies for language in separation agreements. The case that got everyone's attention was the 2014 case the EEOC filed against CVS. The EEOC challenged a number of provisions, including a provision that required the departing employee not to disclose or use confidential information without the prior written authorization of CVS's HR officer. CVS's separation agreement did include a sentence in a separate covenant not to sue section that read, "Nothing in this paragraph is intended to or shall interfere with employees' right to participate in a proceeding with any appropriate federal, state, or local government agency enforcing discrimination laws, nor shall this agreement prohibit an employee from cooperating with any such agency in its investigation." That disclaimer, however, as good as it sounds, by its terms, only related to a section of the separation agreement that was different than the confidentiality section. The EEOC concluded that this confidentiality promise could lead employees to believe that they could not pursue their rights under Title VII and other federal laws. CVS ultimately prevailed against the EEOC, but that's because the EEOC had filed suit against the company without going through the mandated conciliation process. However, that does not mean that the case should be ignored. There are lessons, important lessons, that employers can learn from the CVS case. Employers first should avoid unnecessarily broad language concerning confidentiality. Most importantly, employers should include a strongly worded disclaimer about the employee's protected rights to communicate and cooperate with any agency, akin to the disclaimer that we saw in Blue Links. And that disclaimer warning, by its terms, should make it clear that it applies to all portions of the separation agreement.
I want to talk about the concerns of another agency, federal agency, with regard to confidentiality provisions, and that's the National Labor Relations Board, that regulates not only union issues, but also in the non-union context, protected concerted activity by non-managerial employees. This board, like the EEOC and SEC, has had concerns with provisions providing for secrecy in employee separation agreements, at least as it relates to non-managerial employees who enjoy the benefits of Section 7 of the National Labor Relations Act. For example, just last year in 2018, Shamrock Foods was found to have violated the National Labor Relations Act, Section 8A1, with a confidentiality requirement in a separation agreement applicable to non-managerial employees that required them to keep secret not only traditional trade secrets and confidential business information, but, quote, any personnel or corporate information, close quote. As many of you who've dealt with unions know, the NLRB has real problems when you're telling line employees that they're to keep personnel information secret. They have broad rights to talk about employee and personnel issues. To show you that this issue can strike close to home, there's also a 2018 ALJ decision from the NLRB involving Baylor Medical Center, in which a board ALJ found that Baylor's separation agreement included confidentiality language that was unacceptable under the NLRA. Turning to another federal issue involving confidentiality and separation agreements, let's talk about the impact of the Defend Trade Secrets Act of 2016. That statute not only provided new and strong protections for companies' trade secrets, it also required that with regard to employees and independent contractors, if an employer is going to require confidentiality, they need to include a certain disclaimer in that agreement or cross-reference to a policy the employer has that includes the disclaimer, so employees don't think they cannot engage in certain protected activities. If the employer has confidentiality obligations but does not include the Defend Trade Secrets Act disclaimer, then the employer cannot sue the employee under that federal statute and recover exemplary damages and attorney's fees, though they can recover other elements, important elements, such as injunctive relief. A lot of employers are disturbed by the requisite disclaimer under that federal statute because it includes such things as reminding employees of their right to file retaliation lawsuits. So some employers have chosen not to include the Defend Trade Secrets Act, thinking that if they want to sue the employee, they'll either sue and give up the right to exemplary damages and attorney's fees, or they'll sue under state law and avoid the issue altogether. But your company needs to make a conscious decision about what you want to do about the Defend Trade Secrets Act disclaimer. Okay, with all of that said about confidentiality, let's talk about some drafting advice. First of all, as Amy alluded to earlier, you want to draft confidentiality provisions in a deliberate and reasonably narrow fashion. You don't want to include sweeping confidentiality provisions that are not drafted with careful thought. For instance, you shouldn't be telling a rank and file employee that they're not to discuss employee or personnel information. And you also need to be mindful of what the SEC and EEOC has to say. So very importantly, perhaps most importantly, you've got to include a carefully crafted disclaimer, as Amy's discussed, in your separation agreement that addresses the concerns of these various agencies and federal law. And as Amy pointed out, don't fall into the CVS trap. Make sure your disclaimer, by its terms, applies to all provisions of the separation agreement, confidentiality provisions, cooperation provisions. non-disparagement provisions, etc. And also, again, when you're doing a RIF, a group RIF, really consider whether it makes sense or is necessary to try and have confidentiality of the agreement provisions in those releases. After all, employees are not going to, in a RIF, are not going to keep what's happening secret. And we have concerns about whether you really should or want to be doing that in that context. Now, let's talk about some other covenants and provisions we find in separation agreements that can raise the concerns of these agencies we've talked about under federal law. Amy?
So essentially all of the legal concerns we've been talking about with regard to confidentiality clauses also apply to non-disparagement provisions in separation agreements. In the CVS case, the EEOC challenged the non-disparagement clause along with the confidentiality clause and other clauses as well. As Bob mentioned, in the NLRB case against Shamrock Foods from 2018, the board also found a broad prohibition in the separation agreement on making disparaging remarks to be contrary to employee Section 7 rights, the right to engage in concerted activity. Federal courts have questioned the appropriateness of non-disparagement clauses in releases in the FLSA context, Fair Labor Standards Act, finding that preventing an employee from speaking truthfully about his experiences is in strong tension with the remedial purposes of the FLSA. Therefore, carefully and narrowly tailored wording in a non-disparagement clause, together with a clear disclaimer, I know we said that a lot already this morning, but it's very important, to your agreement. Employers often include in the separation agreement an obligation for the departing employee to cooperate with the employer after the employee leaves the company. I think this area really comes up the most, or where we hear it the most, is when an employee is leaving who may need to be a witness for the company in some important ongoing lawsuit. But it is in these situations in particular that concern is even heightened, because the provision cannot suggest that the employee is being paid for his testimony. Accordingly, in those situations, employers are really probably better off limiting any payment to the former employee to just reimbursement of reasonable expenses that result from the cooperation.
Okay, I want to talk briefly about a provision we find in confidentiality agreements that's become more important in recent years from a business perspective, perhaps because of the prevalence of business data being maintained electronically, and that is return of property provisions. You want to be very careful in drafting a return of property provision, which should be in any confidentiality agreement, to make it clear that you're talking not only about paper, but about electronic data. A problem our clients are facing, and it often can lead to litigation, expensive litigation against employees later on, is employees are more and more keeping electronic data. They're keeping that valuable spreadsheet to use at their next job. And after all, that data belongs to you. So you want to have a return to work obligation provision in your agreement that makes it very clear that the employee is to return all electronic data, and not only to return originals, but to keep no copies. And by the way, this is such a pressing issue, you may want to think about addressing this in exit interviews, reminding employees that they're not to keep spreadsheets or other data on their home computer or elsewhere that belongs to the company or related to the performance of their work. I do want to make one point, that under the law of some states, like California and Massachusetts, and a variety of other states, employees have the right to maintain or obtain post-employment a copy of their personnel file or personnel documents. Well, with your return to work provision, you're not concerned
Return of property
provision. Thank you, Amy. You're not worried about them keeping a copy of their employment application and their reviews. That shouldn't be your primary focus. You're concerned about trade secrets and confidential information. So don't focus on the fact that they kept a copy of their basic personnel documents. Focus on them not keeping key business electronic data in paper that's important to your company. Now we want to switch gears. We want to talk about what's key to building an enforceable release. It has long been the case under federal law and the law of various states that for a release to be effective, it has to be, quote, knowing and voluntary on behalf of the employee. And over many years, a common law test developed for what is a knowing and voluntary release. And the tests under Texas law and the laws of the various states and the federal courts tended to be relatively similar and focus on the same list of non-exclusive factors, with no one factor being controlling. And a good illustration of this is the Fifth Circuit's view under the common law knowing and voluntary test as to when a release is enforceable because it was freely given. And that is, here's an example from the Ollie versus Plano Independent School District case from 2009. And the Fifth Circuit said factors to consider include, without limitation, the employee's education and business experience, the amount of time the employee has the release in their hands before they have to sign it, the role of the employee in deciding the terms of the agreement. You often won't negotiate with an employee over what they're going to get, but strangely enough, if an employee does negotiate with you over the terms of the agreement, it makes enforceability even more likely. The agreement needs to be clear, the Fifth Circuit tells us. And the Fifth Circuit says whether the employee was represented by counsel is an important factor to consider in whether you have an enforceable release, or at least was advised to seek an attorney's advice. And finally, it's not only advisable, but it's critical that any release involve new consideration, new money that the employee would not otherwise be entitled to. So if an employee under an employment agreement or a severance plan is unequivocally entitled to an amount without having to sign any kind of release, that obviously cannot form the basis for consideration for a release. Now, I want to turn to Amy because the whole world changed in this regard as to what is knowing and voluntary for our clients in 1990. Could you explain, Amy?
Sure. For those of us who've been practicing law in this area for many, many years, which includes your two presenters today, the requirements that Congress enacted with the Older Workers Benefit Protection Act in 1990 marked a significant change in how we prepare separation agreements. Reacting to the waves of reductions in force in the 1980s, which impacted many older workers, Congress became concerned that employers were taking advantage of those workers by pressuring them to quickly sign complex releases with very little information about the reduction in force. As a result, as part of the Older Workers Benefit Protection Act, the OWBPA, Congress created a new list of requirements that had to be met before release of age discrimination claims could even potentially be considered knowing and voluntary, and therefore enforceable. First, remember, all the requirements must be met. Also, it's the employer's burden to prove that the agreement complies with the ADEA, the Older Workers Benefit Protection Act. It is not the employee's burden to prove that it doesn't comply. There are also additional, more rigorous requirements we'll talk about this morning, applicable to termination programs involving 2 or more employees, as opposed to isolated one-off employee terminations. So what are those requirements? First, the entire agreement must be in writing. That sounds pretty simple, but the agreement must be drafted using plain language geared to the level of understanding of the employee involved. So an agreement for an executive who's represented by counsel may be written slightly differently than an agreement for a non-supervisory hourly employee. However, we still suggest that you avoid legalese, avoid technical jargon, avoid long, complex sentences that could be misinterpreted. Certainly no misleading or misinforming language should be included. The agreement must not be an effort to sell by exaggerating the benefits the employee is getting, and the agreement must plainly state that the employee is waiving rights under, among other laws, the Age Discrimination in Employment Act. When this law first came out, we saw some employers trying to just refer to age discrimination or just refer to the ADEA, and that is determined not to be sufficient. The release cannot purport to release future claims, that is, claims based upon acts or omissions occurring after the date the employee signs the agreement. Generally, though, the employee can promise to take some future actions, like agreeing to retire or to not seek reemployment with the employer. But note, a very recent new Vermont law bans no rehire clauses with employees who settle discrimination and harassment cases. So again, this is an area that you need to keep an eye The employee must weigh the claims only in exchange for consideration in addition to anything of value to which the employee already is entitled. We've talked about that some already. But do not point to anything such as PTO payout or bonus to which the employee is arguably already entitled and just tie that into the consideration. If you feel need to put that, the reference PTO payout or bonus in a separation agreement, it must be clear the employee is going to get those benefits, the PTO payout or bonus, even if he does not sign the agreement. Likewise, if the employee is entitled to some severance under an existing agreement, that is not contingent upon a release. You need to separate that severance out from what is actually is going to be consideration for the release. Bob, you want to keep talking about some of the other requirements?
Requirements, yes. Another requirement that must be in a release for there to be an effective release of federal aid claims is advice from the employer to the employee to consult with a lawyer. Specifically, the statute requires for an enforceable release that the employer must advise the employee in writing, open quote, to consult with an attorney prior to executing the agreement, close quote. The problem we saw, Amy talked about back in 1990 when she and I were both practicing and this law was new, what some people would do. And what some lawyers and employers that I think were too clever by twice were doing was they were trying to shade this language because maybe their boss said, well, we really don't want to advise them in any very strong way to go see a lawyer. So they were saying things like, you have the right to see a lawyer. We've told you you can see a lawyer. We've told you you're advised to see a lawyer. And they don't want to say, we advise you to see a lawyer. Well, that worried us. And we talked about whether that was really complying with the statute. And then what we saw, for example, early on in 2002 with a Delaware case, a First Circuit case involving American Airlines, a federal district court decision out of Dallas by a Bush appointee to the federal bench, was court saying, if you shade this language, if you don't come out and actively advise the employee in writing to seek the advice of counsel, you will not comply with this requirement, and guess what? You don't have an age release. So, for example, in the Cole versus Gaming Entertainment case, the language read, employee acknowledges that he/she has been advised to consult with an attorney prior to executing this agreement. And the court in that case said, that's not good enough, your release is unenforceable. Now, I will tell you, there have been district court judges that have been more forgiving, and there are judges like this one who have been very strict. Well, if you're like me and Amy and you want to rest well at night, don't play games with this language. Come out and as the court in Cole said, in an active and present tense way, tell the employee to seek the advice of counsel, such as the company hereby advises you to consult with an attorney. Okay, another requirement that many of you are familiar with for an effective age release is that you must in writing give the employee a period of 21 days in which to consider the release. The 21 days arises from when the employee receives the final version of the release. If you continue to negotiate and revise the release with the employee, the 21 days normally cannot run until the last material change has been made and the employee's been presented with that final version. There are instances where you can agree that minor changes are not a material change, though I would never do that with an employee who isn't represented by a lawyer. So once you give the employee the agreement, the release, they have 21 days to consider it. The day after they get the release is day 1. They have through day 21. You cannot pressure the employee or incentivize the employee to move faster. And many of our clients, for very good business reasons, on occasion want to do that. You cannot do that. Now, one natural impetus for an employee to move quickly is the 7-day revocation period we're going to talk about expires more quickly if the employee signs early, and therefore they might end up getting their money earlier. But you never want to suggest to an employee that you're pressuring or encouraging them to move quickly. They get to take their 21 days. Amy referred to the different requirements associated with an employment termination program or exit incentive termination program. An exit incentive termination program is a voluntary exit incentive program, like some of you've had, where employees are offered packages to voluntarily leave. An employment termination program under the ADEA regulations is an involuntary group termination program. And when I say a group, I mean 2 or more, not a big group. So if, for example, your company is reorganizing the executive suite and 3 vice presidents are leaving as part of that reorganization, that is generally going to be a covered employment termination program. And in that instance, with those 2 or more employees, it's not 21 days. It becomes a 45-day consideration period. And as Amy and I will talk about, there are also written disclosure requirements separate and apart from the agreement that must be satisfied. And those requirements, as we'll discuss, are sometimes not easy to satisfy. I want to talk about the revocation period. You cannot agree to waive it. Even if the employee is represented by an attorney, you cannot waive the 7-day period. So the agreement is never effective until 8 days after the employee signs. And you should provide for the 7-day period. You must provide for it in the agreement. And as I read the statute, you also need to provide clearly in the agreement that the agreement shall not become effective or enforceable until that revocation period is expired. So include that language as part of the 7-day revocation period. Also, don't miscalculate the 7-day period. Day 1 of the 7-day period is not the day the employee signs. It's the day after. And also, bear in mind, don't shortchange the employees on the 7 days. One thing that worries me is the concept of requiring the employee to mail the agreement back to you or hand deliver the agreement back to you, and then saying they must have completed that process within the 7 days. Because if you think about it, if you're supposed to have 7 days to think about revoking, but you make it clear that they have to get it back to someone before the 7 days runs, one can make a pretty compelling argument you haven't given them 7 full days. That's why, by the way, I increasingly like providing in the agreement that the revocation is made by electronic mail to a specified email address for the responsible person in HR management to receive it. That's not required, but obviously you can send an email late on the 7th day without any trouble. But whatever process you want to take, the regulations don't provide a procedure for who's supposed to get the revocation and how it's supposed to be delivered. So don't leave that question uncertain. Providing your release a reasonable process for employees to revoke. Now I want to turn to Amy to talk about probably the most difficult part of ADEA releases, which is the informational disclosures.
So, informational disclosures have created a challenge, a true challenge for employers and employment lawyers from the beginning, in part due to the imprecise language in the statute. In addition to requiring 45 days to review the agreement, the employer needs to provide information regarding any class, unit, or group of individuals covered by such program, any eligibility factors for such program, and any time limits applicable to such program, as well as the job titles and ages of all individuals eligible or selected for the program, and the ages of all individuals in the same job classification or organizational unit who are not eligible or selected for the program. Employers often struggle in these situations to identify the decisional unit, which is that portion of the employer's organizational structure from which the employer chose the persons who would be offered consideration for signing the waiver and those who would not be offered consideration for the signing of a waiver. The term decisional unit has been developed to reflect the process by which an employer chose certain employees for a program and ruled out others from that program. As the EEOC has told us, this decision or this determination must be made on a case-by-case basis. Every situation is going to be different. Case law and regulations provide some guidance for determining the appropriate decisional unit, and they should always be referred to. and we do suggest that you consider involving counsel before preparing the disclosures. I will say, as a practical suggestion that I like, and I know Bob does as well, is that sometimes a good place to start is just reviewing the organizational chart or charts that identify the affected group or groups of employees. That sometimes gives you a good picture. Other practical reminders include reminding yourself that the purpose of the informational requirements are to provide an employee with enough information regarding the program to allow the employee to make an informed choice whether or not to sign the waiver agreement. The employee needs enough information to assess whether the reduction in force had a disproportionate impact on older workers. So I think this is really a good point to go back to. After you've prepared the initial disclosures and before they're finalized, really ask yourself, if I was an employee and I was being asked to sign this agreement, would I have the information that I need to make my decision? And if you think it's not clear to you, you need to go back and kind of redraft. Bob, you want to talk about some more points on this decisional unit?
Absolutely. I want to share a little bit of good news today in terms of developments, which is that in the last several years, including as recently as last month, we've seen federal court decisions that express more forgiveness in terms of how precise and how perfect the disclosures and other elements of ADEA waiver compliance need to be. And now, I'm not encouraging you to take this lightly, but I do have some good news to share with you in that courts are indicating, for example, with how you describe the decisional unit, that some deference has to be given to the individual employer. For example, last month, in a case involving AT&T in federal court in Pennsylvania, the judge explained that, quote, assuming that the employer's identification of class unit or group of employees from which the employees selected for separation were chosen reasonably describes an existing organizational unit within the company, the employer's designation should stand. In other words, the employer should be given some deference, and I think to some extent that's because describing the decisional unit as hard as Amy and I try with clients is sometimes not an exact science like we would like it to be, and it's difficult for federal judges to fairly second guess an employer who's made a good faith effort to describe the decisional unit. Also, this is part of a bigger trend just to be a bit more forgiving about how employers comply with these ADEA waiver requirements. For example, just in December, a federal judge in Kansas pointed out that the requirements for an ADEA waiver, including the disclosure requirements, are frustratingly, quote unquote, imprecise. And therefore, it's inappropriate, as some courts had done earlier under these waiver requirements, to say that strict application is required, or and absent strict application, the release is unenforceable. Now, I don't want to suggest you should take this lightly. We still hear courts say strict application, strict compliance is required by employers, and if they get it wrong, even a little bit wrong, their waivers are unenforceable. So be careful. And one point I will raise is, I really believe in determining how to describe the decisional unit, which is a legally sensitive and difficult issue, and how to draft the disclosures as a whole. It's key to have a lawyer involved. I would not want to be a lay HR person charged with drafting one of those provisions without the advice and counsel of an attorney who's familiar with the requirements. And I say that only because it's really tough to get it right, and looking at the case authority is important to getting it right. Now, I want to talk some more about another requirement for the informational disclosures. You've got to identify in the informational disclosures, quote, any eligibility factors for the program, quote unquote. So the question arose early on after these requirements were established in 1990. Well, what does eligibility factors mean? Well, the EEOC, when they came out with their regulations on the waiver requirements in 1998, made it clear in their view that what that meant was you simply had to say who's eligible to receive benefits, which generally speaking is going to be any terminated employee who's being offered severance. However, some federal judges said that doesn't seem right to me. And early on, there were courts that said, we think eligibility requirements means explaining what criteria you used as to who to let go within the decisional unit and who to keep. So you had employers including language that said things like, we considered skill sets, business needs, performance ratings in deciding who would be selected for the program and who would not. So what is our advice and what have we done? Well, again, caution is very much the way Amy and I approach things, and therefore do both. Explain that all employees who are being terminated and being offered the severance benefits are eligible for the program, and offers at least some cursory explanation of the criteria used for who would be separated and who would not. And then you've touched both bases, and you make both sets of federal judges happy. I want to talk about another requirement, which is your disclosures have to identify any time limits applicable to the program. Well, that certainly means you're going to restate the 45-day notice or consideration period. You're going to restate the 7-day revocation period in your disclosures. And if your program has any other applicable time limits, those should be included in the disclosures as well as according to the regulations. Now let's talk about another vexing issue, which is Amy described the fact that you have to disclose the job titles and ages of all individuals selected and not selected. And so how do you format that table, that information? Well, in 1998, I indicated the EEOC issued regulations, found it 29 CFR 1625.22. There's also important regulations at 2.3 that have to do with the enforceability of age waivers. And in those regulations, they included a template, an example. And what you see on the screen in front of you is a screenshot of their table they used for disclosing job titles and ages. And what I try and do, again, being cautious and always wanting to feel good that I have hopefully an enforceable agreement and disclosure, is I like to follow what is, to the extent of practical and appropriate, the EEOC model, and you can see how it appears with job titles there on the left, individual ages listed, and the number of employees in that job position and with that age selected and not selected. I want to turn back to Amy because she and I have talked a lot over the years about practically how do you construct the table and what are concerns associated with what's included and not included in the table. Amy, can you share your thoughts with us?
So some practical thoughts on this table. First, the regulations prohibit the use of birth dates in lieu of ages. You actually have to put the age in there. And then you should identify what specific date was used to calculate the ages. The regulations also require the use of precise titles, which sounds simple enough, like mechanical engineer too. Don't use shortcut titles, don't use abbreviations, but sometimes company documents have different titles for the same position. I know there are plenty of you listening today who can identify with that. In that situation, I would just use the title that you think employees are more likely to recognize. Then you need to organize the information. Sometimes this is a lot of information in these that you're providing in this table. So you should organize it in a readily approachable format for the reader, such as titles sorted alphabetically, ages listed chronologically. And last, you want to address any unique features of your program explicitly in the disclosures, such as, for example, sometimes some of the employees selected for the program have actually been offered other positions in the company. And again, if you're thinking what information would the employee want to have in order to make this decision, that may be information that's relevant. So there's sometimes information that's not going to actually fit in the table, so you can put an asterisk and go ahead and put that information at the bottom of the table. Other practical thoughts. Include any appropriate introduction as part of your disclosure. A well-drafted disclosure tells the story of what is happening and why. You don't want to just put the table in there. When Bob mentioned the regulations when they came out, we started seeing some companies just putting as an attachment to the separation agreement just the table itself. That's really not sufficient. You should start the disclosure by, and one thing we do, actually identifying why you're providing the information, and specifically that explaining to the employee that the company is required to do this. It's required to give this information to the employee as part of this federal law, the Older Workers Benefit Protection Act. You should understand how to approach the disclosure for a risk that may occur in successive increments. That can be complicated and something that needs to be really thought through. Recognize the unique challenges if there's a voluntary exit incentive in program, that you're giving employees the opportunity to voluntarily leave in exchange for benefits. Don't simply make the disclosure available to employees. Actually provide each employee a copy at the time they receive the separation agreement. And then you should be able to prove receipt, that the employee actually received it. There's a recent case where the employer could not prove that the employee received disclosures or even knew that they were available. Bob, you want to talk about one of our favorite topics, covenants not to sue?
Yes. There are two vehicles in a settlement agreement or separation agreement or other release for telling an employee that they're giving up their right to sue. One is a release, which simply says you release claims. That if the employee sues in violation of that release, you have what's called an affirmative defense, so your lawyers will assert and say, these claims have been released, you have to dismiss the employee's lawsuit. The other mechanism is what's called a covenant not to sue, where the employee in express and affirmative languages says, I promise not to bring a suit. I promise not to sue. Well, under the ADEA disclosure requirements, the EEOC has been concerned about covenants not to sue. Why? Because employees retain the right always to bring a suit to test, to challenge whether the employer's disclosures and other documentation complies with the ADEA waiver requirements. And they are concerned that a covenant not to sue might send the message to employees that they can't bring such a challenge. They don't say that covenants not to sue are per se illegal, but they make it clear, the EEOC does, that the agreement as a whole cannot, through a covenant not to sue, confuse employees about their right to bring a challenge. So what happened is, when these regulations came out in 1998, is some employers, again, being very clever and bright and trying to deal with this issue and keep their covenant not to sue, said, you know what we'll do? We'll explain that our covenant not to sue in our separation agreement does not, while an employee can't generally sue, they can still bring a suit that challenges whether the agreement satisfies the ADEA. Well, if you sit down and try and explain that to a welder in an agreement, you'll find out it's not a very easy task. Often it's not a very easy task to explain that to a vice president. Well, IBM thought they could do it. They kept their covenant not to sue, and they included an explanation in their agreement as to what the covenant not to sue covered and didn't cover, and that it didn't cover a challenge to whether the agreement satisfied the ADEA. Well, it was very lawyerly and relatively lengthy, and what happened is some clever plaintiffs' lawyers brought lawsuits all across the country involving large IBM RIFs and said, look, that provision is so lawyerly and so complicated that it makes the release not reasonably understandable to employees as a whole, and therefore the agreement should be deemed unenforceable, not knowing, and voluntary. And guess what? A host of federal courts, including the 8th and 9th Circuit, said, we agree. Your explanation in an effort to keep your covenant not to sue is so complicated, we are going to deem your release not knowing, involuntary, and unenforceable. So what a lot of experts have done, and what we generally advise, is that you rely on the release and you avoid covenant not to sue language. Some in-house attorneys, some general counsel, some lawyers like covenant not to sue language because in theory, in many states like Texas, it might conceivably give you the right to seek attorney's fees if the employee sues. It's not worth it. Our clients don't sue employees for attorney's fees over these claims. So seriously consider not including covenants not to sue. Also, You can't waive employees' rights to file a charge. So generally speaking, avoid the use of charge in your agreements. Don't talk about the fact that you've released your right to bring a charge. The EEOC is going to find that objectionable and think that employees are going to think that they can't bring an EEOC charge. Your agreements should provide generally that they can bring an EEOC charge, but they're waiving the right to monetary or personal relief arising out of any ensuing lawsuit over their Title VII or other EEOC claims. Next, beware of other provisions that the EEOC says are prohibited. For example, the EEOC under the ADEA waiver requirements does not want you including penalty provisions that say, employee, you will be punished if you bring a lawsuit challenging this release. So they don't want to see attorney's fees provisions that say, you'll have to pay our attorney's fees if you sue in violation of this release. They don't want to see liquidated damage provisions like Anheuser-Busch had. They don't want other penalty provisions that say you will be punished in this way, monetarily or otherwise, if you bring a lawsuit in violation of this release, because they want employees to feel free to challenge the releases. Also, clawback provisions, tenderback provisions, or ratification provisions are also unlawful. So you can't have a provision that says if you sue challenging this release, you have to give the money back. That is not permissible. So one final point I want to make is, remember, there are state laws with unique requirements. Under Minnesota's state anti-discrimination law, instead of a 7-day revocation requirement, there's a 15-day revocation requirement. West Virginia has unique release requirements, like including a reference to the state bar free toll-free number so employees can find lawyers. As Amy said, in Vermont, no rehire provisions in agreements are prohibited. As many of you know, there's special language for releasing unknown claims in California under California Code Section 1542 that have to be included. And now there are new requirements in California as it relates to sexual harassment and other claims and separation and settlement agreement language. Well, that's all we have today. I hope you've enjoyed our presentation. I do want to emphasize that for those of you who submitted questions, we'll get back to you in some fashion, either by telephone or email. We won't fail to respond to your good questions, and we see there were some good questions. And we really appreciate you joining us today for this important and practical topic.